So it's my great pleasure to welcome you to today's Milbank Forum, Banks Behind Bars, Convicting BNP Paribas and Credit Suisse. This forum is co-hosted by the Milbank Forum and by the NYU Program on Corporate Compliance and Enforcement. And I wanted to thank Milbank for its sponsorship of the forum, which allows us to do these type of programs. We have a very esteemed panel for you today with a tremendous amount of expertise on these cases, and I will introduce them very briefly. So to my right, we have Danny Alter, who until extremely recently was the General Counsel of the New York State Department of Financial Services, DFS. And in addition to being their Chief Legal Officer, he has overseen the department's International Sanctions and Enforcement Program, which was implicated in these cases. And he is currently a fellow with the NYU Program on Corporate Compliance and Enforcement. To my right here, George Kanellis is Global Head of Litigation at Milbank, Tweed, and he rejoined Milbank after serving 4.5 years at the SEC, most recently as the SEC's co-director of the Division of Enforcement. To my left is Andrew Goldstein, who's an assistant U.S. attorney in the Southern District of New York. And as he's in the office's money laundering and asset forfeiture unit and prosecuted the case against BNP. And he was previously of Paul Weiss. To my right further is Drew Hruska, who's of King & Spalding. He has worked primarily on the Credit Suisse, but also was involved with the BNP Paribas case. And he has previously worked in the DOJ under Larry Thompson, who is the author of the Thompson Memo, which those of you who came out of my or are in my business crime class would know well, or in Jeff Miller's compliance class. So welcome everyone to the forum, and we will use our normal structure, a series of questions and answers to the panel, and then we will leave time at the end for student questions. So I wanted to turn first to Drew to tell us something about the facts of these cases.
Well, I'm going to address Credit Suisse, which I was heavily involved in. I guess I should make one caveat at the beginning, which is under the plea agreement with the Justice Department, there's a requirement that we not contradict any aspect of the agreement. So I'm just going to give you the bare bones here. I should say there's probably another caveat in order as well, which is that there's enough in this area of law to be accurately described that you shouldn't interpret anything I'm saying as a prescription for action. There's a lot to talk about just to understand it correctly. The Credit Suisse last year in 2014 had a series of agreements to resolve a very long-running matter which involved international tax and securities issues. There was both a criminal resolution as well as a series of civil regulatory resolutions. The criminal resolution was with the Department of Justice. Credit Suisse pled guilty to one count of what was essentially a conspiracy to assist in the preparation of false tax returns, and paid a total of $2 billion in respect of that resolution, which includes both a fine component and a restitution component, with the restitution paid to the Internal Revenue Service. That conspiracy involved allegations both of tax violations, but also there was a securities, basically what was a securities registration issue, whether the bank had been, whether bankers had been properly registered to be selling securities in or into the United States. And the bank was sentenced in November on those counts. And the SEC resolved its matter with the Justice Department, its matter with Credit Suisse, and Credit Suisse made a payment of $196.5 approximately $1 million in respect of that resolution. That was pretty much exactly the same issues that the Justice Department had examined in terms of securities violations as well. Then there were also two banking regulatory resolutions, one with the Federal Reserve Board, which is the federal bank regulator, and the Fed imposed a civil monetary penalty of $100 million and also imposed a series of conduct requirements for the bank to execute in conjunction with the Fed. And then finally, there was also a civil regulatory resolution with the New York State banking regulator, the Department of Financial Services. And in that respect, there were a number of conduct requirements, and there was also a civil monetary penalty of $715 million. Is that enough?
Thank you very much. And Andrew, could you tell us briefly a little bit about BNP?
So, BNP Paribas is a Paris-based bank. After an investigation that lasted about 3 years, BNP agreed last June to plead guilty in federal court to conspiring to violate U.S. economic sanctions laws. And that guilty plea and conviction was part of a global settlement that BNP Paribas did with my office and with Danny Alter's office, the Department of Financial Services in New York State, with the New York County District Attorney's Office, which worked closely with our office in the investigation, with the Federal Reserve, which was BNP Paribas' principal U.S. regulator, although Department of Financial Services was its New York regulator, and an entity called the Office of Foreign Assets Control, which is part of the Department of Treasury that monitors U.S. sanctions compliance. And the crux of the issue and what was alleged and what BNP pled guilty to and agreed to a lengthy statement of facts is that over the course of more than essentially almost a decade, the bank willfully violated U.S. sanctions laws against Sudan, Cuba, and Iran, and worked with other entities to move money through the United States that the U.S. had prohibited banks from doing. And in particular, the Sudanese conduct was viewed as particularly egregious in that more than $6 billion of money was moved effectively on behalf of entities controlled by the Sudanese central government at a time when the United States and some other countries were trying to stop the regime that was a corrupt and violent regime.
Thank you very much. These cases are a great lens through which to look at some very important issues having to do with corporate criminal enforcement policy. And just a word of background. So since we have convicted corporations, we do so regularly. We've done so for a long time. However, since around 2003, we switched our policy, and publicly held firms are very rarely convicted. They're almost all channeled through pretrial diversion agreements, specifically deferred prosecution and non-prosecution agreements, which enables prosecutors to impose monetary sanctions and mandates on firms, but not to formally convict them. This avoids collateral consequences, and if there is such a thing, the reputational penalty triggered by conviction. So these cases are a very interesting lens through which to look at this practice as well as conviction, since a number of people, including some judges, have criticized the Department of Justice for letting corporations off the hook in not formally convicting them. So what I wanted to look at today in this panel is to use these cases to take a look at, well, when should we convict, when should we not convict, what types of sanctions. I also want to look at some of the coordination issues that come up involving collateral consequences and coordination between the federal and state. And then there's also some special issues having to do with these particular types of crimes, because most crimes involve bad conduct by the firm, where the conduct itself causes a corporate crime. But some of these convictions of financial institutions are convictions for banks for failing to be good gatekeepers, where banks are required to know their customers to make sure their customers are not engaging in money laundering or violating sanctions laws, and don't satisfy their legal duties to do that. And then that's criminalized. So there has been a great deal of attention to the fact that the Department of Justice regularly lets publicly held firms avoid formal conviction. And this has been challenged and criticized on a number of levels. And so what I thought I would do before we get into this particular case is have a brief word on why conviction matters. Is there something fundamentally different about conviction that can't be achieved through a deferred prosecution or a non-prosecution? And George, I thought I would turn to you on that one first.
So you're, thanks. By the way, I didn't realize this was the Milbank Tweed Forum until yesterday. And now I know I'm here.
Sure you did.
I thought we should start investigating.
I feel like Ronald Reagan. I bought this microphone. So a few thoughts. Your question: why does conviction matter for a corporation? Assumes that it does matter, and I don't think anyone who looks at the regulatory landscape that we have today would say that a conviction doesn't matter for at least one reason, and that reason is we have built into all kinds of laws and privileges in the United States and abroad debarment for people who have certain status, and people would include individuals as well as corporations. And very frequently there is debarment from certain privileges, like doing business with a government in certain contexts, and from acting in a certain manner, for example, acting as a broker-dealer or registered investment advisor. If you are convicted of a crime, at least if the crime has some connection to the financial markets, you're going to be automatically debarred from doing all kinds of things that you absolutely need to do in order to conduct business, unless you are exempted from those collateral consequences of the conviction by action of the, in many cases, variety of regulators who are responsible for administering the various regulatory regimes that create the critical debarment. So that's at a very, very practical level. One of the things that you're going to hear about in our discussion today is there has been a great deal of focus on those collateral consequences, and I think sometimes you hear frustration by the Department of Justice over the fact that the Justice Department can't predict. The Justice Department, ideally, when it takes an action as grave as criminally prosecuting a corporation, ideally the Justice Department wants to know, what are the consequences of my action? If I'm directly imposing the sanction that I call a fine, or some form of corporate reform, the imposition of a monitor, that they understand, but they also want to understand what other results and consequences they are inflicting, either because they want it inflicted, or because they don't want it inflicted. But the inclusion of remedies that they know about and a raft of remedies and consequences that they don't know about is something that the Justice Department is very wary of embracing. So they want to know about those consequences. And in many cases, you will hear that there have been convictions of corporations coupled with broad exemption from almost all of the significant collateral consequences of that action. And I think we need to step back here and realize no one's going to prison when you convict a corporation. And there is, in many, many ways, a civil resolution, such as a fine imposed by the Department of Financial Services or a fine imposed by the SEC, has absolutely identical consequences to a criminal conviction. And in many cases, the civil resolutions that I'm referring to, for example, a consent decree with findings of fraud coupled with the imposition of a monitor, significant fines, and disgorgement of ill-gotten gains, that doesn't just walk and squawk like a criminal conviction. It is in all substantial manner a criminal conviction. And many of those civil remedies carry the same collateral consequences, absent exemption, that criminal cases do. So I do think that you're going to have to examine the civil path and the criminal path to determine what legal consequences flow. But I think that in both cases, you're talking about actions that are very, very similar.
So, Andrew, would you agree with that?
I think that it is true that as part of figuring out the settlements and the guilty pleas in both the Credit Suisse case and the BNP case, one of the key things that made it possible was to work with regulators so that a company could be required to plead guilty to a crime and suffer a conviction without effectively shutting down. And prior to these two cases, conviction was effectively off the table in a lot of respects for large companies and large financial institutions. And to be able to have possible conviction as something that is an option that a company could actually fear happening in the process of being investigated for crimes, I think is a very good thing and a powerful thing, and something that you would want the Department of Justice to be involved in investigating and be at the table, not just with a civil regulator.
But one question that comes up is, if the central difference between a conviction and a DPA is the collateral consequence, and if we convict and then get rid of the collateral consequence, why is it so important to convict? What is,
I think there is.
I'll turn to both of you first, but first you.
There is something else that a conviction carries. A company that has pled guilty to a crime or been convicted of a crime now has a criminal record. And there's a requirement at sentencing where judges can impose fines and also can impose a compliance program. That can definitely be done through the regulatory process. But the fact of the conviction and the impact that has on the company's behavior going forward, when there is a real fear that if in a further investigation, if they don't have their house in order, that they could be facing a new investigation where they have a criminal record. That, I think, is more serious than a company that is facing an investigation where they don't have that stain on their reputation.
And a DPA wouldn't do that?
I don't think
cause that stain, or an official enforcement action by the SEC?
I think that they are perceived differently. That a conviction is a harsher penalty. It does have more unpredictable consequences that companies are clearly worried about. But simply the fact of the conviction, I think, is a materially different thing than a DPA is, and is perceived differently by the public, is perceived differently by shareholders. And I think you know that simply because companies don't want to be convicted. And it's not just because they're afraid of the collateral consequences. It's even if we do whatever we can to control consequences to innocent third parties, companies still don't want to have to face the conviction. It matters to them. And the reason it matters is because it is harder for them down the road to get away with any sort of bad conduct if they have a criminal record.
I think there are a couple of things that both George and Andrew said that are worth expanding on, because this is an area that's difficult to understand. I think the people working in this area sometimes don't always think through all of these things to their conclusions. Both George and Andrew use the concept of predictability and can't predict, and use it several times. And I think there are basically two components to this analysis. There's sort of an emotional, sometimes even a political component, and I think Andrew is speaking to some of that. If you push that to the side for a second, I'm not writing it off, I'm just saying push it to the side for a second and try to think what's going on within the company. Companies are largely economic actors, and although they're people and their emotions are become relevant, from an economic perspective, the most important thing is predictability. What a conviction does is it throws a much larger degree of unpredictability into the dynamic in a couple of ways. One is this collateral consequence issue we've been talking about. And even when we say, well, there have been DPAs, people have worked it through, even in some of these recent cases where those collateral consequences have been worked through in the context of highly regulated industries like banking, there's been a lot of, what's going on below the surface is a tremendous amount of work to try to work through all those issues. It's not a given. And I'm sure Andrew would back me up on that. A lot of work both by the company and by the Justice Department in many cases. But beyond that, nobody really knows what the effect of a conviction will be on a large, regulated publicly owned financial institution. What it would be if there were some further offense, how it would be considered. And I got to throw this into the dynamic as well. People outside the United States just don't understand it at all. It's very difficult to explain in a global financial world what the incidence of a U.S. domestic corporate criminal conviction means. And so there's a lot of work to be done there as well. So what I would submit is that a substantial component of the additional increment of penalty from a conviction is that unpredictability. I know that's not what DOJ goes into it really expecting. I think DOJ works pretty hard to try to understand exactly what the punishment being inflicted in is. But I think that nonetheless is what happens. There's a lot of work done to make sure that by both sides to try to make sure that the judge will sentence within the agreed range as well, and a variety of mechanisms to do that, which I think are outside the scope of this talk. But that's another element of unpredictability. Judges sometimes don't like, they won't necessarily like the terms of a DPA. They also won't necessarily like the terms of a plea agreement. And so that factor has to be considered as well.
I wonder if I could just jump in and add, make a finer point on what has already been said, because people have been talking about a certain type of collateral consequences, and I think those are been identified as the kind of legal fallout that happens in connection with a conviction vis-a-vis the types of business lines that certain institutions can engage in further. I would just add, on a much more fundamental basis, there is a second type of collateral consequence, and that is what goes on within the institution itself. And I think just to add to what Andrew was saying a moment ago, it is fundamentally different for management to have to deal with a criminal conviction than it is dealing with some kind of civil or deferred resolution. People lose jobs. And although corporations are large behemoth entities, particularly the ones we're talking about now, when you're talking about the level of significance that these allegations carry, the people at the top who have to ultimately make the call are held to, I think, a much more strict standard of answerability. So the notion that a company, even though an individual won't be charged, will be ultimately convicted, has collateral consequences for management going forward, which fundamentally, I think every human being is concerned about his or her position, reputation, and career. And that's actually just a psychological dynamic that I think plays heavily into this, having sat at tables where you have bank representatives that know they only face a civil monetary penalty, and that is seriously the only thing that they're going to have to contend in explaining to the board or shareholders, and those that feel they're seriously facing a criminal conviction. There's a very different attitude in those negotiations. So I think it's important to take that into consideration as well.
I wanted to get each of your views on one particular facet of this before we turn into the specifics of this case, which is, having looked at a number of the DPAs, we often have DPAs for very serious crimes. You see DPAs done often because the prosecutor's unable to charge the collateral consequence. So it's not because of the collateral consequence. It's not that the prosecutor didn't think it was bad conduct. The collateral consequences were too big. The Department of Justice, as we all know, doesn't have clear guidelines on when to convict and when not to, such that someone looking at a conviction would be able to say, oh, if I see you convicted, I know that not only was there a lot of wrongdoing, but management also did X. It is likely that management didn't self-report or didn't fully cooperate, but you see that a lot in the DPAs as well. So you can't say it's a strong signal if you're convicted and the DPAs don't look like this. Same with management getting fired. In many of the DPAs, the firm has clean shop of management. And the DPA itself articulates what happened in a way that could have a stigma effect if people are reading them. So what I'm trying to figure out is when the DOJ goes to pull the convict versus DPA lever, we talk about stigma, but can there be a differential stigma if the DOJ doesn't have a clear policy to let us know what these two things mean? So I know for sure why this decision was made and not that one, and if people get fired in DPAs just as well. So ignoring collateral consequences. We're just focusing on the stigma. Can that be?
I think one way that that gets addressed, and you see it in some of the DPA cases, and you see it in the Credit Suisse and the BNP cases, is through a very thorough statement of facts that the corporation is required to admit to. And it's effectively an extremely detailed plea allocution, and it is something that sometimes in the civil context you don't get, because you end up with a resolution that is short of an admission of wrongdoing. And I can only talk.
But is it more for a conviction than a DPA? That's what I'm trying to get at.
I think what you had said is that you were concerned if the DOJ guidelines don't give you a clear, this automatically falls into conviction, this automatically falls into DPA. And that's true, although the guidelines, as I'm sure you can all look at, that are public, they're very thorough, and ultimately it's about the exercise of judgment, which is what prosecutors do not just in corporate criminal cases, but in all criminal cases. And looking at a pattern of conduct. In corporate cases, it's harder because you do have the collateral consequence issue. And you often have corporations that are trying very hard to cooperate and to do things that would tilt the scale potentially toward not being as aggressive as a prosecutor normally would. But in the end, I think what you had asked about is, well, how do you judge? And one way to judge is looking at the statement of facts. And if you read that statement of facts, you should be able to, if you read the BNP statement of facts, I think you will understand why that was a conviction. And if you read some of the statement of facts in the other cases, there may be things in there, and I haven't read all of them, but there may be things in there that would give you a clue as to why that didn't amount to a full conviction.
Actually, what I was trying to focus on is, given that you give a statement of facts in both convictions and DPAs, and that convictions are higher risk, what is it about the stigma of a conviction versus a DPA? There's a clear view by many prosecutors that a conviction has a higher stigma. Danny was talking about this too, and yet if the statement of facts could be identical in the two cases, and if management can be fired identically in DPAs and NPAs, and we can manipulate collateral consequences in both, to some degree less with convictions, but I've seen cases of where the parent gets a DPA and then we convict a subsidiary in one case that was created for purposes of being convicted so that we could not have bad collateral consequences on the parent, right? So we can basically target the collateral consequences at a previously non-existent firm, which allows us to control the collateral consequences. So then the question is there still some stigma that's different, and can that be true if there isn't a clear policy that would allow the public, when it sees you were convicted and you weren't, to know what that means? What is it about the firm that would get it convicted so that they can predict oh, I know they did X, that these DPA guys didn't do.
I would like to hear from Drew in terms of, from the private side. I imagine that companies do see a clear difference between these things.
Companies see a clear difference, and I do think there's an additional increment of stigma, but I don't think it's black and white. I think it's sort of a continuum. I mean, DPAs have collateral consequences. I'm sure everybody on this panel will agree with that. It's just that nobody out in the wider
easier.
business world who's not focused on this really understands exactly what the difference is, understands what the ramifications will be, and therefore it's this additional element of unpredictability. But I
Yes.
agree that there's more of a stigma, but it's hard to define exactly what it is, but I think it's incremental, not kind of black and white.
Now that you've switched hats.
I agree with Drew. I just think that, so right now, we're sort of in a new world of considering the consequences of conviction, especially of financial institutions. And no one knows. I mean, you could be the most sophisticated practitioner in this area, spend your whole life in it. And if some major financial institution like a Credit Suisse calls you and says, well, what could happen to me if I were convicted? Drew and his team would study this matter, for months. And if they did that, they would say to Credit Suisse, we think the following will happen, but we really don't know. When you consider, just think about it. If you're a corporation, especially a big international corporation, one day you may decide that you want to purchase a mining operation in Swaziland in South Africa, and it's then and only then that you will learn that there's a special regulation that's not even South African, but just local to Swaziland that says convicts don't get to buy mining properties, and that unpredictability causes everyone enormous jitters. If it's a deferred prosecution agreement, but for those collateral consequences, it's hard. You're being charged with a crime. You are being charged in court with a crime. You are being required to state and acknowledge in great detail everything you do, which is a full acknowledgement that you committed a crime. And any thinking person who knows you've been charged with a crime in federal court and you've had to admit it, and what you've admitted is criminal, will draw the conclusion that you are criminal just like they would if you were convicted. But that unpredictability element would be gone, because you will never be in a position where someone says, check the box, you have to check that you've never been criminally convicted, and you can always check that box if it's a DP. And so I think that's the big difference. I also think so much of what we're talking about, to the extent there's stigma, and I think Drew would say, and I would say, there's some stigma associated with criminal prosecution, because everything about corporate charges has this overlay of public relations and customer relations to it. And so to the extent that there is some perception among people, like people in this audience, I think there's no difference between the two. They walk and squawk the same, and they are the same. They're both ducks. But there's a perception among people here that there's some greater severity to criminality, and that's worse, and that people actually distinguish, that there's logic that distinguishes those who are convicted versus those who have a DP. I think largely it's politics, it's questions of predictability, it's questions whether bank regulators are willing to tell you up front you're going to get an exemption. I think there's many factors that have nothing to do with distinguishing between who's bad and who's worse that guide these things. But to the extent that there's that perception that being a convict is really bad, you don't want to have it. But over time, I mean, if none of you had prepared for this, maybe some of you had prepared for this, or at least read the title of today's panel, so you would know that Credit Suisse and BNP Paribas have both been criminally convicted. If I asked you 2 weeks ago, I gave you a quiz, who's been criminally convicted, who has not been criminally convicted but almost the same, a deferred prosecution agreement, who has a non-prosecution agreement, and who has never been stigmatized with criminality at all, and I gave you a list of the 20 top financial institutions, I bet you couldn't tell me. And even I, who practiced this my whole life, I can't remember. UBS has a conviction or not? It does.
Only the sub.
UBS does, yeah. CS does.
Japanese
JP
sub
Morgan-
to
Japanese
avoid
sub,
the collateral
Does
consequences.
JP Morgan have a criminal conviction? No, but it has a significant deferred prosecution agreement. BNY, Bank of New York, does it have a criminal conviction? I can't even remember if it was non-pros or deferred
It was
pros.
deferred.
It was deferred.
It was a
Over
DBA.
time,
It was a
over
DBA.
time, I knew it was deferred. Over time, if we continue on the same course, in the next 10 to 15 years, we have a trend towards increasing consolidation of big financial institutions, so that the mammoths now have, 500,000 employees and 50,000 business lines. If you apply respondeat superior principles to criminal prosecution, every one of these institutions is going to have bad apples who commit criminal action, including some at the lower level, some at the higher level, but some that someone might choose to prosecute. So 10 years from now, essentially all of the major players, including every place that you do banking, will have a criminal conviction. And I think that we run a very significant risk that to the extent there's any stigmatization of this, we get it all inured to it. And I also ask you the question whether there really should be any stigmatization to this, because we're not talking about human beings. Almost every instance in which there's criminality at one of these organizations, the people who committed it, and usually the people who committed it, their supervisors and their supervisors' supervisors, are all surgically extracted very quickly from the organization, so that the people who are left are not necessarily people who, in any ad hominem way you can think of as associated with this criminality.
That's a really important point, because the dimension we haven't talked about on stigma is time. These are huge institutions. These investigations are huge. They involve enormous numbers of people and facts, and they can go on for years. And it's often the case that people haven't been surgically removed who are personally responsible for the bad acts, because they're long gone. They were removed years before the resolution. And so to the extent that the institution is being stigmatized at time zero, it's really at time minus 3 years or 4 years or 5 years when most of the bad conduct took place. I'd be interested to hear from Andrew how I tried to grapple with when I was a prosecutor. It's a difficult thing to do.
So I wanted to ask Andrew to talk about the decision to convict in BNP instead of a DPA, and then I also wanted to ask Danny to talk about New York's role in enabling that and being part of that.
Yeah, I can only stick to the public record on BNP, but as I said, there is a very detailed statement of facts, and I do think that if you look at that, and I can talk about some of that now, but there are things within that statement of facts that if you compare that to the principles of prosecution of business organizations, which were originally the McNulty memo, has many different names. But if you look at those principles, where you look at the pervasiveness of wrongdoing within the company, the company's internal compliance program, the company's level of cooperation, and the collateral consequences, if you look at all of that and you look at what was in the statement of facts, I think you'll tilt toward this is a company that needed to suffer a conviction. Now, there were several other sanctions cases that came before BNP that all were resolved through DPAs. None of them had the dollar volume that BNP had. Some of them had different sets of involvement of the leadership at the banks, at those financial institutions. But for BNP, if you look at the publicly available conduct, this was a level of conduct that was far more pervasive, went on for a longer period of time, went on even after BNP was ostensibly cooperating with the government and was coming in and self-disclosing, and yet there were still financial transactions involving Iran that were going on. And then there's parts of the statement of facts that talk about how the level of cooperation from the company affected the government's ability to go after individuals.
Actually, could you speak more about the role of the self-reporting and the cooperation? Because there has been some people have suggested in looking at the convict, not convict, that one often sees, one's more likely to see a conviction associated with a foreign firm than a domestic. And one of the issues that comes up around that is that in part because of a different approach to cooperation and self-reporting? And what was the role of that in this decision?
One of the factors that we look at, and we're supposed to look at, is the extent to which, if you can go after individuals, then maybe you don't need to go after the company. Can you achieve the deterrent effect that you want simply by going after individuals? And in this case, I do think that with foreign firms, there are, because of foreign secrecy regulations and laws, and the time that it takes to get materials from overseas, even when foreign countries and foreign law enforcement is being cooperative, takes a long time. It becomes harder to go after individuals. There's statute of limitations issues. There are issues with simply getting records about foreign employees that you don't have when you have mandatory process here in the United States. And as a result, I think that factor where you look at, well, do you have to go for the corporation because you may not be able to charge any individuals, that would tilt toward prosecuting the corporation.
And MLAT will toll the statute.
It'll toll the statute, correct, for individuals potentially and for the company.
So Danny.
Yeah, I'd like to lead into the point you asked by just responding in a moment to what George said, and giving a slightly different perspective on this. I think that what we haven't until this moment expressly identified as a factor in consideration is deterrence. And the question of whether a conviction versus a deferred prosecution agreement has a material impact on an institution going forward as to what it will allow its employees to engage in. I think it's notable that historically, when we went through the list of major institutions, that most of them were identified as having DPAs or non-prosecution agreements. And lo and behold, in the past several years, we have, as a public, been witness to numerous charges of egregious activity in the banking industry on a very wide scale. And one has to ask the question, is it because institutions historically have gotten off too lightly? And if there had been prior convictions in those instances, would the conduct that we've seen in the fallout of the financial crash and in these cases, money laundering cases, would their behavior have been different? I don't know. I don't know whether these convictions will have an impact going forward. That remains to be seen. Will banks now look at what's going on and say, we came to death's door and we didn't like it. And we're really going to control our internal management in a different way and implement different sets of controls to be sure that things don't get out of hand at these enormous institutions, which dovetails nicely with the point that you raised before in terms of how we as a civil regulator work closely with criminal authorities in the BNPP matter.
Actually, just for the audience, can
Sure.
you give them a bit of background on the power that you have?
A lot.
Because it's a special kind of power.
A lot. The royal we. The civil banking regulators, be they state or federal, have tremendous power over the institutions that they supervise. They can curtail business in tremendously significant ways. They can pull the plug on an entire business entity. It's a very, very different dynamic that supervisors have with their institutions than civil and criminal prosecutors from the Justice Department or state and local authorities have with institutions. We, again, speaking largely, like to think that the relationship is open, more transparent than it is with other branches of government, because a good regulator will seek to intervene in times of trouble and try to get ahead of it. So it's helpful to know if there's a problem going on so that it can be corrected before it gets entirely out of hand. But residually, the power is enormous, which really goes to the point which has kind of framed this entire discussion. There are really two models over banking regulation in this criminal context that you can really look to and draw guidance from. There's the prosecutorial model, which ends up in a full-blown criminal investigation, which can be incredibly lengthy, as was stated a moment ago. There are justifiable due process, there are warranted due process protections in place that elongate the period and protect individuals from governmental overreaching. There are standards of proof that can be daunting and can limit a prosecutor's ability to go forward with something that is actually, no one disputes that there's been some very troubling conduct that has been performed. On the regulatory side, you don't face that really at all in the same way. The standards of proof are far lower. You can rely on hearsay in coming to these enormous decisions. And you can be, rather than very club-like, and I don't mean that in a disparaging way, when a criminal conviction is a hit with a club. I think anybody who suffers it would acknowledge that. Regulatory authorities have the ability to be far more surgical in the way they go in and address a problem. And that's what I think enabled, in a significant respect, not entirely, the conviction of BNPP. Because the criminal authorities, state and federal, did not want to bring down a global institution. Makes sense. The implications are enormous, both in terms of European and American, the American economy. The impact on individuals would have been enormous. We saw what happened in Arthur Andersen, and there are folks who've mourned that case long since. And so the criminal authorities were in a hard position, but the conduct was egregious. The bank was, for all intents and purposes, the National Bank of Sudan during a period in which there was genocidal conduct going on. So it was something that we couldn't just look askance at. The collateral consequences, if not tailored surgically, would likely have brought the bank down. They would have prevented them from engaging in a whole slew of business lines that had nothing to do with the finance that was activity that was criminal, and it would have ended the institution. DFS was able to come to the prosecutors and say, hey, we can try to help justice be done here by coming in and looking at the activities that gave rise to the criminal conduct, solely those activities, and shut them down. And shut them down in a way that would quite plainly cause the bank pain. This was not a slap on the wrist, and it was intended to be a difficult situation for the bank. So in connection with essentially what the bank was doing for Sudan was exchanging currency in their oil export operations, which kept the government in place. Every business line that touched those activities was shut down insofar as it happened through the New York branch. And it just so happens all of those activities went through the New York branch. And they've been shut down, it will be for 2+ years, depending upon their slight modification. But it was extremely difficult for the bank to grapple with. This was not a cakewalk. They had to go out. One, they faced the possibility, and in fact have lost customers, significant customers as a result. They had to, in order to sustain their business, go to other banks and ask them and take the risk that their business would be stolen to pick up the business transactional activity that they were barred from undertaking. So when you combine the deterrent and moral impact of a conviction with the very real-world impact of economic curtailment, I think this is a very interesting case to look at as a first step in what may be going forward a new model for resolving these cases. And I would say civil regulators have a long way to go. It's not just the criminal prosecutors who are holding back for many years from seeking convictions. Civil regulators were very hands-off in many respects and didn't want to rock the apple cart. And I think there needs to be my own personal perspective, is a more aggressive stance on both sides, but willing to work with one another so that the punishment fits the crime.
I wanted to follow up on the role of the civil regulator. We have different regulatory models and different reasons why civil regulators have not always been as aggressive. And one of the things we've explored in the past is one feature of the SEC is the 5-person politically divided commission, which, at the top of it, which does create a check on regulatory aggressiveness. Whereas New York's Department of Financial Services has a top person who basically is in charge and has enormous amounts of discretion and therefore can be very proactive. One of the things I wanted to know is we've been using collateral consequences as one of the key things that we're interested in because of a conviction. Do you need the conviction to be able to come in and do the types of mandates you did? Or could you do them on your own without the conviction?
Technically, no, we don't need the conviction. And in some instances, state law was particularly useful because under state law, it was not a mandatory death sentence if the bank took a felony plea. Some collateral consequences under federal statutes require certain things to go into motion, which are deeply troubling for the bank from a business perspective. It was in the superintendent's discretion to determine whether or not the license would be on the line. I would just note that while the superintendent has tremendous discretion in dealing with it, he or she has a top person too. I mean, you can't ignore the political realities of what informs all of this on both the state and federal level. And I don't mean that, again, in a negative way, because it's important. There are certain international implications that need to be considered. There are industry ramifications that need to be considered. So and of course, there's always a judicial review in the context of the superintendent's exercise of discretion. So it's not completely untethered. But I would say that as a result, the agency could be far more nimble and act more quickly. The superintendent was fond of saying that there is constructive competition that goes on between state and federal agencies in this context. Sometimes friendly, sometimes not so friendly, but that's the mix of it. I would note that over the past 2+ years, the institutions, state and federal, have been evolving together. I think in a very positive way, as portrayed in the BNPP situation. And I think as a result of that creative competition, federal agencies are acting more quickly as well. So there is a kind of, I don't know if it's a zeitgeist to what's happening now in the industry, but there is a sense of rules that are coming into play.
George, could you follow up on both the ability for a federal civil regulator to come in and use these very powerful collateral tools coming out of the SEC, and also your sense of the cooperation between state regulators, federal, and federal prosecutors? Is this a competition, or is there much more cooperation happening over time?
Sure. So I guess on the narrow question, if you're talking about an entity that's regulated by the SEC, Danny's obviously talking about entities that are regulated by DFS, and sometimes it's the same entity that will have either the entirety of the unit or various subsidiaries either regulated by DFS or by the SEC. So if you were talking about an institution that's within the SEC's jurisdiction, and that would include any investment advisors, it would include any broker-dealers, it would include transfer agents, rating agencies, a number of regulated institutions, then there is sort of no limit to the SEC's discretion ultimately in dealing with those institutions, and the sanctions can run the gamut from, on one end of the extreme, you can commence a proceeding to revoke the registration of any of those institutions that I mentioned. And for any form of fraudulent conduct constitutes a predicate. There are many other violations of law that also could constitute a predicate, but any form of fraudulent conduct could form a predicate for an action to strip any of those institutions of their registration, and you can't operate as any of those institutions in any of those industries without registration, so you're done. And that is the most draconian result that any regulator or prosecutor can possibly impose, and that's essentially the equivalent of taking out a shotgun and just putting them down, saying
You've got a
"Too bad."
civil burden of proof.
With a civil burden of proof, and you have the whole spectrum of everything in between, any level of fine, any level of sanction, the ability to seek equitable relief, including imposition of a receiver, imposition of a monitor, surgical treatment of particular businesses. So you can do it all. And so I think, I think Danny really now is focusing on, Danny talked about the surgical remedies that were imposed by DFS. And I think instead of talking about someone's status as a convict or a DPA, the really constructive discussion that regulators should be having, and I think do have in many cases, is basically just, put aside who's doing it, civil, criminal, could be anyone doing it. A lot of times the civil regulators have all the same authority as criminal, maybe more. But whoever's doing it, you just ask yourself, you've got a big problem at a corporation. You want to, and what we care about, what we should care about for corporations is we care about compliance with the law, we care about good corporate behavior. And so given that, we sit and say to ourselves, first there's deterrence. I need to punish someone who violates the law so that others will be deterred from doing it. How much punishment should I impose? That's an important factor. Then there's reform. What reform do I want? What's important? Does this company need a monitor? Does it need a new system of internal controls? Does it need a receiver? Because it's so rotten to the core that you need some plenipotentiary to come and run this place. Or do you need something in between? And so that, without putting labels of criminal or not criminal, I think basically if you want deterrence, whacking someone in a way that others will be deterred by. A lot of people talk about all these regulatory sanctions and even deferred prosecution and convictions being just the cost of doing business. Well, one fundamental question is the conduct so bad that you feel as though the word needs to be out on the street that if you do this again, you will not survive? And if the conduct is that bad, then whether it's DFS, the SEC, or criminal prosecutors, the answer should be, we're just going to put this one out of business. If the answer is, well, it's not so irretrievably bad that that's the case, something draconian will be just fine, then you start thinking about the other things. One other comment on this point, we are not America. We are not a model for regulation by like a nascent state that doesn't have a regulatory regime. If you go back in time to the 19th century, that's the genesis of the law that says, essentially, you can criminally prosecute an organization. For all practical purposes, so many of us think of criminal prosecution as a thing that happens to a human being. When Danny and I were prosecutors, when Drew was a prosecutor, almost everything we spent our time on was questions of who should go to prison. We didn't think that much about corporations. A lot of that was handled by the regulators. But in the 19th century, it became clear under the law that you could criminally prosecute an organization. At that time, there was no such thing as a regulatory state. There was no such thing as a regulatory state. And there was also very little there was very few corporate activity, nothing like the prosecutions we see today. Over time, we created all these federal regulatory agencies in the 30s, including the SEC, CFTC, you name it, Dodd-Frank, created more of a proliferation of them. At the time we did so, we created specialty agencies whose whole job was to oversee particular segments of the economy and gave them essentially the power, made them all powerful in those areas. But no one said, let's displace the law of criminal prosecution. I doubt anyone even thought about it at the time, but it didn't displace the law of criminal prosecution. It also didn't displace state law. In some instances, federal law did, but they didn't displace the power of like a New York or any other state prosecutor to bring actions for fraud under the state securities laws. They didn't displace that law. So over time, you have more and more agencies developing with specialized expertise. You haven't displaced the technical authority of the Justice Department to bring criminal cases. You haven't displaced the technical authority of any states. So you have not created any monopoly regimes, just all-powerful regimes. And you flip forward to a world in which we have multi-service financial institutions, many of which are banks and broker-dealers and investment advisors, and like any organization subject to criminal prosecution. And what you have is a cornucopia of agencies and prosecutors, some who act in coordination with one another, some who don't, all with concurrent jurisdiction, including the power of life and death over each of these organizations, sometimes cooperating out of necessity and long relations, sometimes competing. And one of the explanations for why you have, I mean, if you look at any of the press releases here, I'm looking at the one for Paribas. We have the Department of Justice, we have the New York DA's office, Department of Justice, DA's office, New York Department of Financial Services, OFAC, a civil regulator, all participating, all fining. One of the reasons why you see so much concurrent activity is because they can. Not because someone grand and wise decided you should do this or we need to do this together, but because they can. And that competition and concurrent jurisdiction and with the disparate goals that each of those entities pursue helps to explain, in some cases, the result.
We have some time for some questions from the audience, and I would like to ask that you use the mics that are in the back that are on their way forward. And while I'm waiting for a question, I wanted to follow up from something that George said about, well, one of the goals of all of this has to be deterrence. Actually, Danny was talking about that. And the core of deterrence is, in the end, individual liability, because sanctioning the bank sanctions the shareholders, and unless the people who commit the crime think that it's going to hurt them, they can commit the crime and, as you pointed out, leave. They may be already gone. So they're not even around at the firm having their stock options fall. They might be long gone. So when you make the decision to convict, does this also have implications for the individual enforcement and for how you make sure the individuals are in the game? And I wanted to ask both you, but also you defend a lot of the individuals. So
I think the answer is, of course it does. And companies have their own compliance cultures. And part of what the deterrent goal is to make it so that that leadership at companies, which may not be involved in the criminal wrongdoing, but that they actively take steps to make sure it doesn't happen. And I think the companies where you may end up getting criminal convictions or the more serious DPAs are companies where the compliance culture was not robust, or alternatively was permissive and looked the other way. And even if you are not convicting an individual, by convicting a company or putting in a robust DPA, you can change the compliance culture, and you can make sure that through a monitor and simply through the fact that the settlement is out there, you can make sure that the company is putting in resources and efforts to monitor what is happening within the four corners of the company. And that's something that you can do as a deterrent matter, even if you aren't able to convict individuals. Just one comment on George's, I think that all of us who are prosecutors come into this wanting to prosecute individuals, but I do not think we're at a point now where there is a strong enough regulatory regime where prosecutors should simply walk away and not also deal with corporations. That you can do both. And there are certain circumstances where you want to prosecute individuals and maybe you can't because of different reasons. And going after the company is a way of creating deterrence and changing corporate behavior that you would not do and can't happen if you simply leave it up to the civil regulatory regime.
Noah, you had a question.
Yes, thank you. What do we know now that we didn't know since the proliferation of DPAs and MPAs in 2003 about how to design an effective compliance program? What are the surprises? What have we learned? And what are the open questions, especially as it relates to corporate culture?
Drew, why don't you?
Sure. I mean, look, all too often, there's a lot of closing the barn door after the horse has already fled with changing corporate compliance programs. We collectively, the prosecutors, regulators, defense lawyers who have to consult on these things, think a lot about these issues. But it's much easier to change the program to avoid the problem which already happened or happened 10 years ago or happened 20 years ago. The tougher thing is changing really the way corporations approach the program and to have them not see it as a disused book on a shelf, and also not to see it as purely prescriptive, very rigid doctrines, but more to embrace the mindset of compliance, so that then people within the organization will feel free to raise their hands and identify wrongdoing and problems, and so they don't become these issues. Let me add one more thing on that, which is I think, I'm sorry, going slightly digressing, but we've talked a lot about the emerging role of regulators, and effectively how regulators are becoming much more prosecutorial in their outlook. I think that's exactly correct description of what's going on. What we haven't talked about, though, is on this issue of corporate compliance, it does create some problems. If you go back into the past, the relationship between many regulators and heavily regulated industries and the companies was much more, if not exactly collegial, it was much more open. Now, many companies, especially in the financial industry, they view every interaction with a regulator as a potential source of investigative interest, and that has caused people to shut down a bit, can actually foster wrongdoing because there is less likelihood to do what I was just saying, which is raise your hand if you think there's a problem.
Would you agree with that? That you see less, both people coming in, but also, as now that you're on the private side, nervousness from your clients about coming in this new enforcement arena?
Not entirely. I think what we're seeing now, particularly in the financial services industry, is a spate of really bad cases. So the regulators have been more aggressive in resolving those cases. I think, in many things, the pendulum swings. And I think once these cases are resolved and there's a better understanding of responsibility by the company, to the extent that there's doubt now about whether you can come forward and talk. The problem what we're seeing right now is people didn't come forward for so long, and we're up to such dirty tricks for so long, that all of a sudden criminal cases are spilling out. So it's hard for there to be a kind of warm, fuzzy feeling right now between the authorities and the companies. But I am hopeful that there will be a return to a more cooperative and supportive relationship. I think it has to be for a host of economic and business-related reasons. So.
And the final, yes. Can you bring the?
Thank you. I'm interested in the extent to which the outcomes, whether it's an MPA, DPA, prosecution, and also the content of these agreements or the prosecution, the requirements on the companies, are they a result of a decision by a regulator or a group of regulators in concert, or is it a result of negotiation with the entity that's in trouble, and how that sort of plays out in practice?
All of you can take that.
I think it's the latter. It's the result of negotiations. From the Department of Justice perspective, it's going to be negotiations between the company and the Department of Justice. But with regard to large financial institutions, the primary regulators have to be part of that conversation. And so it ends up being a multi-headed hydra of a conversation where there are meetings between prosecutors and regulators, between prosecutors, regulators, and the company, between regulators and the company. And this goes back to one of the issues that came up before about how can regulators and prosecutors work together in some of these cases where they're not at odds with one another. One of the things that was helpful to get the resolution in BNP, and I believe so in the Credit Suisse case, is that regulators were willing to reach an actual resolution at the same time that we as the government made a charging decision.
That's often not the case.
And that is
right?
often not the case. And the problem when that's not the case is companies want certainty. And if we decide that we're going to bring charges against a company and the Federal Reserve is withholding judgment as to whether or not it's going to pull a license, that is devastating for the company, and it makes it extremely difficult for us as the government to go ahead and to make that charge, because we don't want, and there are cases where the wrongdoing is so egregious and it goes to the core of what the company is, that it is perfectly fine for the company to go out of business. I've been involved in some of those cases. But in cases like the ones that we've been talking about here, where the conduct, some of it is old, where it went high up but was not at the core of what the company does or even did, is you don't want the company to go out of business. The harm to innocent people would be insane. It's not something that the Justice Department would think would be in the government's interest. But if you have a regulator who is not willing to reach a resolution at the same time that we do, you end up with the risk that even if ultimately they come around and they say, well, we're not going to pull your license, that shareholders start to flee because of the uncertainty. And so I think to go back to your question, the answer is that it's a product of a lot of negotiating, and in order to get to a place where you can actually convict a large financial institution right now, that has to all be done largely in advance before the final decision comes out, when everything gets settled at the same time.
I wonder if I could just jump in on one point. Everything, I agree entirely with everything Andrew just said, but the flip side frustration also exists, which is a regulator is often concerned with misconduct in real time. And if we know something is awry in an institution, it's the natural reflex, hopefully, to intervene and stop it. But if there's an ongoing criminal investigation, that could complicate that investigation. So it's a difficult balance. I think there are concerns on both sides, and the great achievement is when you can construct a strategy jointly in a way that you can stop any ongoing misconduct and preserve the criminal investigation.
I think we have time for one more student question, and then.
Yeah, in the case of BNPP, do you think if the DOJ had more control over collateral consequences, if they were able to guarantee exemption from sanctions imposed by the Department of Labor, that the settlement would actually be much bigger?
I can't really speak to that. I can say one thing, which is the BNP has not been sentenced yet. And the reason, and this is a matter of public record, the reason BNP has not been sentenced is because the Department of Labor has regulations that are triggered immediately upon conviction. And BNP would not be able to act as in doing some sort of financial advice if the process with the Department of Labor is not resolved prior to the actual conviction taking place. And the conviction actually happens upon sentencing. And so that we are sentencing in BNP has been delayed several months now, waiting for the Department of Labor to make a decision one way or the other.
So I want to thank everyone very much. I want to thank the panel very much for coming, and also the students and Milbank Tweed.